Hey y'all, it's David with I'm So Offended. We are continuing in this series of modification, and this is video 4. And I am not a lawyer, I don't practice law, I don't give legal advice, I don't pretend to. Um, I'm not liable for anything that you guys do, for how you take and receive and what you do with this information. All of this is for educational, informational, entertainment purposes only. And, let's proceed. So, as the last video, part 3, this is part 4. We're nearing the end of trial. I'm being cross examined here. So, this is the baby mama's attorney. Let's go.
Half a dozen police officers testified about your conduct, and you weren't there to cross-examine them. And the Judge Green, made a finding after hearing the testimony of those police officers that you kidnapped your daughter. Isn't that what happened?
Judge Green, Commissioner Green did make the ruling that she made in those temporary orders. We then had trial, and you presented the same.
The later, we're going to get to that, believe me.
He wants the answer that he wants, right? He wanted a yes or no answer. And I was clarifying, and he didn't like it.
The question is, Judge Green made the finding that you kidnapped your daughter, didn't she?
In that ruling, in those temporary orders, she did.
Okay. Now, you got an opportunity to show up. You went ahead and took the oath, and you appeared in front of Judge Sklar, where there was another evidentiary hearing, right?
Yeah, I don't know which one you're referring to. We were in front of SPAR for several hearings.
The hearing I'm referring to is October 24th.
I want to object because I don't see, first of all, there's orders. We're only supposed to go back since the final orders. There are findings now. Already a bond has been lifted. I'm not a danger or a threat to lose. We're only going back a year and a half unless he has a pattern. Then it's all irrelevant now. There's orders, and I pay the consequences for these things.
All right. So, when there is a modification, right, and there's already been orders before, the modification has to do with what has been going on since the last order, right? So there was an order, I believe it was like October 25th or something like that. There was an order that date. And so therefore we do a modification on what's been going on since that order. Now, the order on October 25th was actually, it wasn't a completely new order. So what it really was, it was more so, and it wasn't necessarily a modification either. So it was, what the judge ended up ruling was that it was a court's 85 motion where the court made a modification on its own motion. So it wasn't a modification as far as the legal language that I had actually filed, because it had been more than a year. So it wasn't a modification as far as legal language was concerned, but the judge can make an order on its own motion, Rule 85, to change an existing order without resetting the timeline for a modification. I'm going to give you all a minute to think about that. Okay? So you can have a modification, let's say October 24, 2022. Since then, there was a change in the order, but not through modification, but through relief from judgment, which altered the order but didn't reset the timeline of a year from modification, right? So therefore, I was well within my right to file the petition for modification, because it had been over a year since the actual trial of modification. The only thing that had actually happened was a relief from judgment under Rule 85, which is different and did not reset the timeline. But they think I'm a dumbass because they filed their response stating that the court's modification, the court's relief from judgment, resetted the timeline. However, that's not true. But the thing is, if I didn't know to have had been able to address that, the court does whatever they say. Because even though they know the rules, the judges, they know the rules, they know the law, they know, but if you don't invoke your rights, if you don't call out the rule, then it's as if it never happened. It doesn't matter because they're not going to protect you. They're not your attorney, so the judges won't protect you. They don't give a damn if you don't know law. They won't protect you. So that's why you have to do your research. All right.
Well, the request for the modification is designed to look at what has happened since the last parenting plan was entered.
That's what the judge just said, right?
Mhm.
However, the rule, ARS 25-403 factors require a broader view because I have to make findings on all those factors anytime I am evaluating a request to modify. So it's kind of two different planes that we're on in that regard.
Thank you for explaining.
Because
Okay, I understand.
And that's because of legal decision making is different. Legal decision making is an overall life of the case. Custody is a 1 year.
So we're talking about the hearing on October 24th of 2022. And at that hearing, you did take the oath, didn't you?
Yes, sir.
And there was, the same officers came in to testify again. This time you were present and you had a lawyer representing, right?
At that time, yes.
So this hearing, you had a lawyer, you had full opportunity to participate yourself and through your lawyer. And Judge Sklar.
That was the one time that I used an attorney because I was really, really deep in a hole, and I needed a, proper, because I didn't know too well about custody, and I had only beaten the child support contempt, and that's a separate matter. And then I went into a custody hearing using my administrative knowledge, and it didn't work. So it's a separate matter. So I didn't know as much about custody at the time. So we're talking like 2 years ago, right? So at that point in time, like, okay, I did get an attorney for trial for that matter 2 years ago, over 2 years ago, and at that point in time, and so and it helped out because I'm like, I told them I'm just here for custody. We went specifically down what was going to be addressed, what we were going to talk about, and I basically had the case put together for her, but I didn't know how to properly present it because I hadn't done that successfully before. So seeing how she operated, and she basically pointed out, okay, this is what we're going to do. This is how we're going to do it. Then I'm like, okay, that makes sense. And then we basically worked in tandem to where I was just taking notes while we were going through the trial and doing everything that needed to be addressed and all that. And so since then, in those 2 years since then, since I had the attorney for that, I've represented myself for like over like 10 hearings or something like that, 10 different motions and all this other stuff, and I'm 10-2. So I think I did all right, and this is trial since then, and yeah, and I did all right. So here we go.
Made some findings, didn't he?
Yes, I resumed parenting time. It was great.
And did he make any findings regarding your conduct on the night that Judge Green found you kidnapped your daughter?
Well, he didn't use the word kidnapping at all, and instructed you all to not use it. And I don't have the order in front of me, so I couldn't tell you specifically what it says.
Under the circumstances, didn't.
So, with the judge at the time, he didn't specifically say that what I had did was kidnapping. But in order to give reference to what they accused me of, he said, "Oh, because you'll hear it right now." So, and the judge did instruct him. It's like, no, it's like you can't use the word kidnapping because there was no finding of that outside of the temporary orders. And the temporary orders they got because I wasn't present. And so when it's somebody against nobody, then whatever somebody says is in its entirety they're going to believe. But they use the same exact strategy, same exact witnesses, same exact testimony, and they got the opposite outcome when it came time to trial.
Fine. The court finds that significant conditions will be necessary to protect both Luz and Ms. Hadley from further harm. In reaching this conclusion, the court places at the forefront of its analysis the seriousness of the domestic violence as well as the risk of further custodial interference or kidnapping. Now, I understood you to testify under oath just a moment ago that Judge Sklar did not use the term kidnapping.
No, I didn't find it in the ruling.
I'm looking at the under advisement rule. Well, let me help you.
So my mistake is that he didn't refer to me as having had kidnapped, but he used the term in order to give reference to what they were accusing me of. Like let's say I'm not a murderer, but they're accusing me of murder, right? So, just to point out, like, no, I've never done that. But I mean, just so you can understand the concept, like they're accusing you of murder. Oh, but I'm not a murderer, right? So he didn't use it in the concept of, oh, I'm not a kidnapper. He didn't use it in that sense. He said, oh, but this is what they're saying in the event of, based on their accusation of this or kidnapping. Basically that's what that was.
Get you Exhibit C.
Well, if it's the order, it's the same thing, right?
Let me hand you Exhibit C. Take a look at page 11.
So what he took out is the order, right? And he's basically wanted to point out that the judge did use the word kidnapping, but not so much to call me a kidnapper, but just to say, what they alleged was kidnapping. And so that's what they're doing. And this is just the process. He has to introduce it into evidence. He has to get me to, verify that that's what it is. And, and he's going to ask me to read from it. And that's the procedure of how you're supposed to introduce evidence. Sorry. It's taking a minute to...
You had a chance to look at it.
I'm still reading through it, and actually, I see that he called it here December 2021 incident. That's what I saw. He called it. If I missed it, it wasn't intentionally, and I'll apologize if I missed it.
Your testimony then,
mistake.
A few moments ago, that Judge Sklar never used the word kidnap.
Well, we still haven't found it, have we?
I'm looking at the word kidnapping on base stamp 11 that I just read. The court places at the forefront of its analysis the seriousness of domestic violence as well as the risk of further custodial interference or kidnapping.
You said page 11? I don't see that.
No.
Base stamp 11?
It's base 11. It's page 8 of the under advisement rule. Your Honor, we oversee, although it's in the record.
Okay. All right. Okay.
All right, any objection to Exhibit C coming into evidence?
I believe if he's going to put in some of the order, he needs to put the whole thing in,
I believe
right?
the whole order
I will take judicial notice of Judge Sklar's under advisement ruling dated October 24 of 2020.
All right. Taking judicial notice, right? It's different from taking into evidence. Evidence is one thing. Evidence can be interpreted. Judicial notice of a court order means that it's basically everybody knows it's fact. It's like taking judicial notice of the sky being blue, right? Unless you're colorblind, and even then, the sky is blue, right? The sky is blue. That's like taking judicial notice of the sky being blue. Like it's a fact. This is a judge ruling. That's what it is. Judicial notice means that it has more weight. Like this is what happened, something that happened. As opposed to, if you say, I don't know, if someone submits evidence of there being a God, and someone submits evidence of there is no God, then the evidence is up for interpretation. Although, I don't know, I guess that's a bad analogy because there's no evidence of a God. So anyway, let's continue.
So rather than admitting C, I'm just going to take judicial notice of the entire ruling.
I think that's entirely cool.
All right.
It's proper.
Now that it's all in,
Okay.
we can agree that your claim that Judge Sklar did not find kidnapping was wrong. Can we agree on that? Or do you still want to try to?
I'm just reading this. Is that okay? Or
You told me you already had. I appreciate the interest in consuming more of my time, but the word kidnapping you've read now a couple of times. Is it going to change for you?
okay. It doesn't say a finding. It says he's placing these things to protect Lewis and Miss Hadley. It's analysis of the like he's considering these things.
Mr. Wintery, you've made your point. I get the point that you're making, that Judge Sklar was definitely concerned, and he referred to the incident of December 2021 as being either custodial interference or kidnapping. That's my take on what he's communicating there.
And as you sit here today, Mr. Quintero, are you able to acknowledge that's not only what Judge Sklar found, what Judge Green found, but that's what happened?
No, that's
Okay,
what Judge.
You answer my question. You don't. The other issue that was going on that relates to your past.
I'm not going to lie. I mean, he's an attorney. It's clever. He asked a yes or no question. Basically, am I stating that is or is it? But the thing is, the question was improper. It was improper because he's saying that they found, right? When they have findings, that means when they have evidence, when it's conclusive. And no, there wasn't a finding of that. No. So I was correct in stating what I stated. That no, there was no finding of that. No, that's incorrect. But he just wanted it to sound like I'm not acknowledging that is what they allege. That is what was alleged, and that what they had to make a decision over. But it wasn't a finding. It's different.
For Luz is, at the time you engaged in the conduct that Judge Sklar referred to as either custodial interference or kidnapping, you believe that Luz was your property, your chattel, the word. True?
It was a scenario that I had just tried. That has already been litigated, and there's
so the answer
orders
to my
for
question
that.
should be clear. At that time, you referred to her as your property, your chattel, didn't you?
At that time, I was using that in some documents. Yes, and I apologize for that and paid severe consequences
You
for
say
it.
you paid, but my question is a little different. You wanted to force my client to agree to your parenting plan in order for her to see your property again, didn't you?
I sent her a parenting plan with different language. and I was under the good faith impression that that is what we had.
Now, you were under the...
At that time. At that time.
All right. So when the factors refer to coercion, attempted coercion of a parent to gain an agreement on legal decision-making, you acknowledge that you were doing that kind of coercion to my client, the parenting plan you wanted, didn't you?
No.
I thought in good faith that we had another agreement. I made a mistake.
What he's reading is number 7 right there. Right? So I didn't coerce her. I sent her a letter. She signed for it. I sent her another letter. She signed for it. I sent her another letter. She signed for it, and I sent her a default. And she signed for it. Where's the coercion? This was sent by the mail. She freely put her signature on.
Apologizing for it, and I paid severe consequences for it.
You get to acknowledge what you did. So let me ask you to look at Exhibit R.
He wants the answer.
I acknowledged it in several hearings, sir.
Well, you apparently won't do it here unless I show you your own words again. We're just going through the 403 factors, which is why we're talking about this. Show you Exhibit R. Take a look at the page that begins, I also mailed you a sub-agreement to our contract, should you choose to agree to it voluntarily, in which it outlines how we can share my property equally. You see that page?
I don't see a time, a date stamp, a person to, a person from. I don't see any of that. I see what you said here.
You admit that you sent this text at 12:37 a.m. on the date of the incident we've been discussing.
I believe, as far as rules of evidence, it needs to have information. You need to have a name, a date, all of these things.
Is it your testimony under oath that you do not recognize this as a message you sent my client?
I recognize this. I don't know when this was. I don't know what date. I don't recall.
You're under oath, so this is really important. Are you denying recognize this as a message you sent my client at about 12:37 a.m. on the night we've been discussing?
I don't know when I sent it, sir. Okay. I don't recall when I sent it.
But you recognize that it's an email, a message you sent my client.
It's something that I have sent. I don't know when, but it is true. Yes, sir.
And the message you sent her, I also mailed you a sub-agreement to our contract should you choose to agree to it voluntarily, in which it outlines how we can share my property equally.
He's talking away from the mic, sorry.
Property that you wanted to share equally with my client?
Well, at that time, I was just trying something, and obviously it failed. And so in the context of that language, instead of using the term child, I was using the term property. I didn't know what I was doing then, and I have apologized to it and paid severe consequences for this.
So the my property that you were referring to that you were prepared to share equally was your daughter Lou's.
At that time, that is what I was referring to.
All right. So when Judge Sklar's order discussed his concerns, this was the evidence that he had in front of him. Was your belief at that time that Lou's was your property?
This was one of the things that I believe you had introduced. I don't recall, to be honest with you, but I wouldn't doubt that this was something that you submitted at that time.
All right. Big fine. And at the end of his proceedings, Judge Sklar awarded my client sole legal decision making, didn't he?
Yes.
But as you pointed out, you were given a path by Judge Sklar to work your way back up to getting unsupervised parenting time, didn't he?
Yes.
Okay. He, however, in that process, left my client with sole legal decision making. Right?
Yes.
And Your Honor, we offer C and R.
Instead of C coming in, which is only a part of the ruling, I'm taking judicial notice of the ruling in its entirety. Mr. Quintero, any objection to Exhibit R coming into evidence?
As far as rules of evidence, it should have like dates and all of that stuff. Like it should be, you know. So yeah, I object unless it's proper.
Okay, the objection is overruled. Exhibit R is admitted based upon the defendant acknowledging that he is the person that sent that message to Ms. Hadley.
And with regard to sole legal decision making, Judge Green ordered my client to have sole legal decision making, correct?
She has, yes.
And she did that on August 7th, 2018, September 12th of 2019, and again on November 8th of 2019.
I don't recall the dates.
Does it sound familiar that Judge Green found in her minute entry on November 8th of 2019 that on a review of the history of the case that you failed to meet your burden, that the mother acted in any fashion that would require a review of her sole legal decision making?
Was that a question? He was just reading.
Yes.
Sorry.
What was
the question? Am I denying it, or what?
Do you deny that was Judge Green's finding, a review of the case? There was nothing to warrant a review of the prior orders giving my client sole legal decision.
I don't know what he's
You failed to meet your burden.
Ms. Hadley has always had legal decision making. So, like, if you're gonna read any of like the past orders and continue saying that she has sole legal decision making, all of them say that. I've never actually like challenged it until now, and I think only just the first time.
I think about that just a second, because Judge Green's order was in response to your motion to review my client's sole legal decision making.
Okay, I don't recall. I don't have it in front of me, sir.
I don't remember. That's why I'm trying to remind you that you have in fact challenged it before, and Judge Green's finding was that you failed to meet your burden, that the mother acted in any fashion that would require review of the sole legal decision making.
I don't know that.
Is that ringing a bell now?
If that is what she says, then that is what she says.
Okay.
Not denying something that's on the record if that is what's on the record.
So, with regard to Judge Sklar's treatment of sole legal decision making, do you recall Judge Sklar finding it was your lack of cooperation and the following of court orders that led Judge Sklar to leave sole legal decision making in place?
From what I recall, I don't think we challenged legal decision making at that time, but it's because it's something he has to put as part of the ruling. He has to state that, sole legal decision making remains with and whatever. But we didn't challenge that then. I had that attorney at that time. We didn't challenge it.
You are right that Judge Sklar said you did not challenge it. Are you suggesting that was some trick your lawyer played, or you agreed with your lawyer to not challenge sole legal decision making?
Doesn't matter.
Well, at that point in time, I had no contact with Luz. Clearly, that's like hitting the lottery that I would get that, So we were just there to just start somewhere where we needed to be, which was just resume parenting time with Luz. And so it happened. We got that.
You objected to me using the term deadbeat dad. Do I understand that you objected?
Oh, here we go. Here we go.
Yes, sir.
What do you understand that term means, colloquially or any other way?
Well, it's an insult, is what it is.
But what does the insult mean to you?
So a father who's not involved, and that's not me.
Okay. So because you testified about your involvement, my question is, do you understand that many people use the word deadbeat dad to a father who does not financially support their child?
I filed a motion in limine. I object to anything regarding child support or financial things being addressed here. It's not part of legal decision making or parenting time. The motion in limine is on the record. This has nothing to do with that.
And I approved it for filing. The response deadline doesn't expire until May 15, but since you've brought it up right now, my take on that, Mr. Quintero, is you opened the door to this by you raising the issue in that email of Mr. Wintry disparaging you and calling you a deadbeat dad. So you've opened that door and now he's cross-examining you about that. So I'm overruling your objection to being questioned on that because you opened the door on it.
Oh,
All right. All right. So this is his gateway to try to talk about child support, right? And I've told you guys about the motion in limine to exclude evidence that basically has nothing to do with this. This has nothing to do with this, right? But because he had insulted me and called me a deadbeat dad, that's his gateway to be able to have permission to try to talk about child support and finances. However, when I brought it up, it was because it's an insult. This guy insults me. There's a no disparaging clause, right? And so now he's getting to that, right? And they could do whatever they want until it gets challenged, right? And so the judge is saying, it's like, oh, that I'm the one that brought it up because he insulted me, so therefore he gets to ask about it. But no. But what matters is the definition. So when he asked me about the definition, I told him, oh, it's a father who isn't involved. And that's not me, because I am involved. It's an insult. But they want to try to use it for financial information and child support and whatever. All right. So let me see if I can rewind this just a little bit. Here we go.
Quintero, is you opened the door to this by you raising the issue in that email of Mr. Wintry disparaging you and calling you a deadbeat dad. So you've opened that door and now he's cross-examining you about that. So I'm overruling your objection to being questioned on that because
she overruled the objection, which means he could ask me about it. That doesn't mean that I have to change my position. So when you go into a hearing, you keep your position. It doesn't matter what they say. Just because she overruled my objection doesn't mean that I now change my position. No, I maintain my position. All right? You'll see what I mean.
open the door on it.
oh, okay. My definition was of an uninvolved father. He took it to there. He opened it.
Well, he's exploring with you your objection to that, and he's granted leeway to explore that topic since you're asking him to be sanctioned for addressing you in that manner. Go ahead, Mr. Wintry.
Exploring. Okay? Exploring. So she's giving him leeway to explore. Right? So when you're exploring, you can only find, right? When you're exploring, you're looking for something, right? When you're exploring, you're looking for something. Hold on. Think about this. Let's say they're exploring something that you have and you know, right? So if you don't want to talk about it, are you going to let them find it? No. You maintain the position of it being hidden. If it's hidden and he's been given leeway to explore, would you reveal it just because they have leeway to explore? No. You maintain your position. Here we go.
Do you accept the common understanding that deadbeat dad refers to a man with a child that he is not financially supporting as required by law?
No, it's different for different people. I have heard that some people refer to that, but more often than not, it's about a father who's uninvolved or abandoned their kids. I believe that is where the term is best suited, and that is not me.
Okay, but we can agree that the way many people view deadbeat dad is somebody who doesn't pay child support. That does squarely apply to you, doesn't it?
No, because
Let me ask this. How much do you currently are in arrears for in child support?
I object. This is not proper before the court. There's no, this is my petition, and for the line that said anything about child support, I crossed that out and I put does not apply. And again, it's irrelevant evidence. It's a
Mr. Winfrey,
4D
how is
case.
this relevant to modifying child support or legal decision making?
We're looking at co-parent. That's the principal issue he's raised. The context of which I called him a deadbeat dad on my email was on the co-parenting issue. In that case, it was curbside exchanges. Here, where he's raised his willingness and ability to co-parent with my client for cross-examination purposes. Surely it impeaches his credibility that he's willing to be supportive of my client in her duties as primary residential parent, that he has ducked, dodged, and avoided, and now won't even answer the questions about financially supporting his daughter's medical needs and her food, clothing, and shelter needs.
All right, I'm going to sustain the relevance objection. The dollar amount of arrearages is not going to be relevant to my decision on whether parenting time will be modified or decision making will be modified.
All right.
All right.
I want to be respectful of the court's decision, so I stay away from the dollar amount. The fact that he is not paying regular child support and has an arrearage, is that fair game? And I'm not quarreling.
I don't think there's really any more need to go on this subject. The point has been made. You've made your case why you referred to him in that manner, and I think we could move on to another subject.
I understand, Your Honor. Thank you.
Shut him down again! Feel free to rewind this and listen to what happened. Custody and child support are separate. Separate. And although she gave him leeway to explore, I did not change my position. I stated that it was my petition, my rules. We were not to discuss that. I filed the motion in limine. Shut down. And he's moving on. Let's go.
The questions of your willingness to co-parent. We did talk about curbside exchanges, and did your sister, when you were talking to her today, did y'all talk about this incident where my client was trying to run her down?
It was something that was brought up.
It was in her affidavit, but she never testified about it today, did she?
She read it, actually. She read the part in the affidavit. Well, she was testifying, yes, sir. If that's, she testified about it.
And do you agree that as long as we do curbside exchange, somebody pulls up the curb, child runs from a house, gets into the car, gets out of the car, runs to the house, eliminates the possibility of any interaction between the person driving the car and the person in the house?
I would hope for that to be the case one day, but Ms. Hadley had the opportunity today to apologize to my sister, and she didn't.
Okay.
I asked her the question, and she didn't. She has no remorse for what she did.
Right.
I record all of our exchanges because of my safety and Luce's.
Your testimony, I get it. Of course, there is no evidence of the incident that you say happened.
Yes, there is. Actually, there's pictures of...
Let me ask you this. Do you remember raising this issue with Judge Green? This exact issue, this incident?
I had brought it up, yes, but...
And what did Judge Green say about it?
She...
Remember, there's a record of this, right?
Yeah, which I'm trying to remember,
right,
sir.
So, your thoughts.
I think, I don't have the order in front of me, and I don't want to lie.
Refused to take it up. She didn't give it any credit or weight. She made no finding in support that incident happened. Isn't that right?
I don't recall, sir.
No
honestly.
police report was filed?
Yes, there was a police report.
Do you have a copy of that? What exhibit is that?
It's years ago. I didn't submit it here.
All right. You say there's a police report filed, but there's no evidence of that. There was no charge filed.
No, I didn't know, what to do.
Okay.
So I'm not an attorney, sir. I don't know how to do this.
The idea that you were guilty of kidnapping because there wasn't an arrest, a prosecution, a conviction. You kind of dismissed the fact that there were judicial findings of kidnapping. Have I summarized kind of our discussion so far?
No, sir. I didn't dismiss the fact that there were findings. No, the findings are what they are, and I apologize for my actions, and I paid severe consequences for them.
I've said the same thing.
But with regard to the incident involving your daughter, your citing is the reason to make your daughter go through the alternative to curbside. That incident, Judge Green made no findings. True?
I don't recall, but no, she didn't.
There's no 911 call contemporaneous with the incident that you've offered as evidence.
Let me try to think, because it was a long time ago. I don't remember if I called the police.
Did you offer a 911 call into evidence today?
No, sir.
Or in any other hearing?
No, not a no.
And we agree there was no arrest, no prosecution, no conviction.
No, sir.
So, using your standard, this incident should not play a factor in the court's decision, should it?
Okay. I would hope that the court would consider, for the best interests of Luz, drop-offs that we previously did at the police station downtown, which was down the street from me. And that was an agreement Ms. Hadley and I had actually made in a ruling of May 8, 2020. Okay, we both agreed for that drop-off.
But you do believe, apparently, that even though no 911 call, you've offered no exhibits of police reports, no arrest, conviction, no findings from any family law court, you believe that's the evidence the judge should consider in ordering exchanges to continue at TPD parking lot. Is that your testimony?
My testimony is that just not in my home until, Ms. Hadley had the opportunity to apologize. I'm willing to forgive. My sister can forgive. She stated so. I want to move forward. I do. I really do.
And one last thing, I guess, that should put a pin in this is that you all were actually doing curbside exchanges all the way during COVID, right?
No, sir. Actually, we have never, ever done curbside exchanges. All of the exchanges have been at the Tucson Police Department downtown, or they were prior at across the street at the, there's a bank there, a Vantage West, I believe.
So you're denying my client's testimony that during COVID, you all had agreed to and were doing successfully curbside exchanges.
No, there's never been a ruling for that. We used to exchange and we've never done it. No, sir, we've never, only one time. Okay. One time I dropped off Luz in front of her parents' home. That was a one-time text message agreement that we did. Right. We only did that one time.
So your testimony, but if the judge finds that your testimony is not credible, and that my client testimony is credible, that in fact y'all were doing curbside exchanges outside your residence during COVID, if the judge finds that's the truth, would you agree that there were no incidents during the time, you say there weren't curbside happening, but during that period of time of COVID, were there any adverse interactions between my client and your household?
No, because there was never any curbside pickups, ever. There has never been.
And there were no, obviously, any adverse interactions during the exchanges that you were doing at bus stops and in parking lots, right?
There was adverse interactions when I would have an Uber driver. We were exchanging at the Burger King, which is off of St. Mary's. A friend of mine drove me and Luz over there, and I took Luz out of her seat and then walked her across the parking lot, and I took her there to Miss Hadley. She was standing outside. I set her down, and then I walked away across the parking lot. Miss Hadley then abandoned Luz, left her by the car, walked across the parking lot to yell at my driver. It was a female friend of mine. This wasn't someone I was dating or nothing, just a female friend. She started yelling at her and banging on the window. That happened at that Burger King. There was another time at that same Burger King that I had an Uber driver that she came up to the window and started yelling at him.
This isn't coming against my time.
All right, well, he was answering your question whether there were any negative interactions during exchanges.
Yes or no, and then if I was foolish enough to ask, well, tell me about it.
Okay.
Yes, there was, sir.
Well, I didn't ask that.
Okay, go ahead with the next question.
So, the idea of curbside exchanges, you've agreed that nothing bad happens or can happen if the child gets out of the car, runs to the door, or runs from the door to the car. Was your answer a few minutes ago, because there aren't any interactions. And that's your testimony now, isn't it?
No, sir, because we've never had curbside pickups.
Okay.
I've repeated this.
You have repeated it, but you haven't answered the question, but I believe you, in effect, have. Because you failed to give us anything that could happen badly with a curbside exchange. My next question, sir, deals with the parenting plan that you have proposed. Do you agree that you have, with the current schedule that the court ordered that is in effect now, you're able to establish and maintain your relationship with your daughter?
I try my best. I've only had to make
I understand. That's yes, I have. No, I have not. And I understand you to say you're doing the best you can.
Yes, I haven't missed any time with her.
Fair enough. The question about Luz's feelings of you. Have you ever had my client deny to you Luz's affection towards you? Have you ever heard my client deny that Luz loves you?
Have I heard her say that? Or what do you mean?
Never mind. I didn't mean to make it that hard. My client has characterized your interactions with Luz as her friend, her playmate. And you remember hearing my client characterize that, your relationship with her as that?
Yeah, I've heard her say that, yeah.
Okay?
Okay.
And, but you've never heard her describe you as somebody Luz does not love. Is that correct?
Not that I recall.
All right.
Trying to think.
I want to ask you finally, you were talking about deceptions to the court in order to influence parenting time. And you suggested this business with a car seat fall into that category. Did I understand your testimony correctly?
The car seat is about the safety and welfare of Luz.
Right. I didn't mean to confuse you. I'll move on. There have been specific findings by other courts in this case that you intentionally misled the court. Isn't that true?
If they made that finding, they made that finding. I'm not disagreeing. It is what it is. I try my best when I come here. I'm not an attorney.
Well, telling the truth doesn't require you to be a lawyer, does it?
No, sir.
All right. And my question to you very simply is, it is in fact true that you have intentionally misled the court in this case, isn't it?
What are you referring to? If the court made a finding, then it is what it is. You know, sometimes I don't like the court findings, just being honest, but it is what it is. I still have to follow the order, don't I?
You still have Exhibit C up there.
Yeah.
If you will take a look at page 6, the first full paragraph from the bottom.
Okay, I see it.
Read that, would you please?
The court finds that Mr. Quintero has intentionally misled the court.
How did you mislead Judge Slar?
To be honest with you, I don't recall in what context he was using. Let me see.
Are you saying you can't read it, or you disagree with it?
No, I'm continuing. No, I don't disagree. Because
good for you. Did he in fact continue by saying he, referring to you, amplified the proceedings by filing duplicative pleadings and making legally irrelevant arguments?
Yeah.
While he has disavowed those pleadings and arguments, the court is not persuaded that he was acting solely out of ignorance of the law. has his history of attempting to coerce agreements out of Miss Hadley reinforces the court's conclusion that his purposes were not proper. Now, what Judge Sklar was addressing, the context of that hearing, was you're saying the same things you're telling us today. I'm not a lawyer. I'm doing the best I can. I misunderstood. I didn't mean to call loose my property, my chattel. And that this is what Judge Sklar's response to those statements by you.
Now, I know that sometimes hearing all of these things, right? You know, when you're in your own trial and the other attorneys saying all of these things, but their statements are not evidence. He has to be able to get me to respond to his questions that would validate the question that he's asking, right? So if he says all the stuff that he says, that's fine. That's fine. You know, I maintain my composure. He's full of lies. It's a bunch of lies, right? And even like the judge rulings, you know, in the sense that, you know, they don't have the full facts. They don't know everything, you know, because it's not what you can prove, it's what you can convince the judge of. Evidence is irrelevant, you know. It is because, I mean, OJ was found not guilty of murder, right? So it didn't matter that he killed those people, you know, it's what you can prove. And so while I go up against attorneys with experience and, you know, and I lose when I go up against them, you know, so therefore a judge makes a finding and a ruling and saying, well, this is what we concluded, you know, but that doesn't mean that that was the entire truth. If I didn't know how to properly present the evidence, if I didn't know how to introduce it, how to ask the questions, and that was how I failed for most of, you know, most of the lifetime of like my cases and things I've been involved with, because it was lots of errors that it took me to reach success, right? And so I knew it was going to be tough going into this modification. I knew it because they have all these court rulings of saying that I did this and I did that. And in those court trials and rulings, I didn't know what I was doing. You know, I mean, the kind of evidence I have, if I had known how to submit evidence then that was different. Things would have gone very different. But unfortunately, that's what we all go through. A lot of us go through that. We try and do this on our own, and we're going up against their attorneys, and they don't care about the truth. They only care about what they can prove. And so, yeah, I had a lot stacked against me. A lot.
Okay, if that's what he found, then that's what he found. Judge Sklar is a great judge, and you know, I suffered the consequences for this, sir, and I paid for them.
Well,
it's the 5th time I've said that.
The conclusion there is that he also found that you did something relevant to our hearing today. Mr. Quintero attempted to modify Luz's medical records to contain self-serving information about his parenting. This wasn't done with Luz's best interest in mind, but to portray Mr. Quintero in a positive light. Do you remember what you did that Judge Sklar was talking about here?
Actually, what had happened is I was completely shut out of Luz's therapy. They had no knowledge whatsoever of what Luz's environment is. Oh, I provided Casa de los Niños some information regarding Luz's household when she is with me, because it's different when she's with me, when she's with her mother. So a proper therapy provider is going to take both households into account, and they never took mine into account. I was completely deprived of the entire process, and so I had to.
You perceived it that way. What was the thing you did that Judge Sklar found was your attempt to modify Luz's medical records to contain self-serving information about your parenting? What was the thing you did?
Oh, I told him that there's no charge of kidnapping. They're accusing me of kidnapping, but that never happened. That wasn't, I wasn't arrested or convicted or nothing like that.
So you think that's what you just now said? You think that's the attempt to modify Luz's medical records to contain self-serving information about your parents?
No, I didn't make the attempt. I made a request. I made a request to them through the proper channel of their administrative assistant.
Attempt is my word, or is that what Judge Sklar found?
Oh, okay. If that's what Judge Sklar put down, that's what Judge Sklar put down.
We get that he put down. Put it down. It's right there in black and white. The point is, that's what he found because that's what was true. That's what you were doing. You were trying to skew the medical records for Luz to change the perception of your parenting, and that you were not doing that with Luz's best interests in mind, but to put yourself in a positive light. Do you see that's what Judge Sklar found was the truth? It's not that's just what's on the paper. After he heard the evidence in a contested
he's testifying basically.
With you present and
Where's the question?
represented, that's what Judge Sklar found. Do you agree that that's what Judge Sklar did?
I agree that that is what Judge Sklar put down. Is if he made that finding because I made a request about them not using the word kidnapping, and if that's why he did that, because it's not specific. So if that's the reasoning for doing that, then I believe it fits that context.
You don't think this is specific enough?
I mean, it's pretty broad. Attempt to modify Luz's with self-serving information about his parenting.
So,
I believe that.
Hold on a second. Mr. Winnery, I want to just alert you, it's 2:47, so you've got 13 minutes left to use your time as you see best fit.
So today every time you have been confronted with really terrible things you've done in the past, your response has been, pay terrible price, apologize for it, it was really wrong. And yet, every time you say that, doesn't it kind of call into question what Judge Sklar found the last time that's what you did to explain things you've done, is that it is not done with Luz's best interest, but you are trying to portray yourself in a positive light. You're doing damage control. Is that really what's going on here?
If there are things that happen that aren't true, I have the right to defend myself and to say this didn't happen, this isn't true. This in particular, Judge Sklar, he put it down because if he says he found it, then he found it. I'm not disagreeing with him, even though there are things that I felt needed more context, because it was actually Ms. Hadley that asked him to change the report, which I have an exhibit, but I didn't have time to submit it. But it's an exhibit of Ms. Hadley telling them to change the report. So, but as far as this,
you hear that you're doing it even this moment, instead of just acknowledging.
I acknowledge this, sir.
You acknowledge that he wrote it.
Yeah, I acknowledge that he wrote it.
But then you're denying the facts, the events that Judge Sklar found.
I'm not denying anything.
Well, I'll let the court decide that. Your Honor, I need to make sure I've offered K and W. I believe I did, but I'm not.
W is in, K, I don't remember.
It's in kilo.
What is K? I don't have that in front of me.
K is a ruling from Judge Green, February 3, 2022.
Okay.
I think you may have already taken judicial notice.
And what you've marked as K, it looks like it's not a complete copy of that ruling. So instead of admitting K, I'll simply state that I am ordering taking judicial notice of Judge Green's ruling, February 3, 2022.
Thank you, Your Honor.
In its entirety. All right, Mr. Quintero, thank you. You could step down and return to your seat.
Okay.
Your Honor, if I've got about 10 minutes left, if I counted right.
Yeah, 11 minutes.
I'm sorry?
11.
Oh, well, I'm embarrassing the riches.
Now it's 10.
Your Honor, we're here.
These motherfuckers are just laughing. They're just laughing and they're having a good time and they don't care that they ruin other people's lives. They're just laughing. They're having a good time ruining other people's lives. They don't care. And these people care.
Mr. Quintero's motion to modify. He carries the burden. The first question, the two big areas that we're dealing with are legal decision making, the second being the actual parenting time. We're asking that you maintain the status quo in this matter, with my client retaining sole legal decision making, and that we maintain the current parenting schedule.
Now, so this is conclusion, this is closing arguments, right? So status quo, right? That's where things are the same and you want to keep things the same, right? That's what he's doing. They don't want, they want her to say with sole legal decision making and the same parenting time schedule, which at this point in time, it was ridiculous. It was like every other week for like 8 hours, like on Sunday, right? With no incremental increase or nothing like that, right? So that's what he wanted to maintain. That's what they want, and I believe, and I showed it in one of the earlier videos a month or two ago, right? So that's what they're doing. The closing arguments regarding the points that they want, and supposedly they made all the arguments and evidence and whatever to validate their points in their conclusion.
Allowing Mr. Quintero to supervise parenting time with the restrictions that currently are in place.
I want to just double check, did you misspeak? Because I believe he's having unsupervised.
Yes, for 6 months now.
You said supervised.
If I wasn't speaking,
Okay.
and I apologize, and I thank Mr. Quintero for correcting me before. So the current arrangement is working, we believe, with the exception of the exchanges, which there's simply no good reason for us not to go to curbside exchanges. It'll be easier on lose. It'll be legit. It'll maximize Mr. Quintero's parenting time because it eliminates having to send a kid on the bus and the other wacko things they're doing in the parking lots. They should not be doing exchanges in Burger King or police department parking lots when all they need to do is drive up. We absolutely welcome any admonition from the court or restriction that the parents are not to have any interaction with one another, any family member or member of the household. That it is just a standard curbside. The kid gets out, runs in the door, or the kid comes out the door, runs right to the car. And that's the only thing that makes any logical sense at all. And the arguments to the contrary just don't make any sense. Your Honor, with regard to legal decision making, 40303 specifically, or the court finds by preponderance the significant history of domestic violence, that sole legal decision making is where we end up. You cannot award joint to a parent about whom that finding is made. Judge, we have had numerous, every court that has considered this case, both when Mr. Quintero absented himself by refusing Judge Green's repeated entreaties to raise his right hand to be sworn in that hearing and in the contested hearing where he was represented by counsel, findings were made that what he did that night was custodial interference or kidnapping, either one of which are listed in the offenses in 3601. There's been no evidence in the time since then to undo that finding. And we believe that sole legal decision making is what the law requires to be continued at this point. Having made that finding, the court has a right to impose certain restrictions. The one that we believe is most applicable here is that Luz is not ready for overnights with Mr. Quintero. Other than that, the current parenting schedule is working. We're not saying there'll never be overnights at some point, but Mr. Quintero's anger towards my client is the same findings were made by Judge San Angelo at the very beginning of this case, the litigation in this case.
Okay. All right. So we're done with part 4 here. All right. So this one we got to hear where I shut down child support, their mention of it, their attempt at bringing it up. We're going to go ahead, continue with closing arguments and the order All right. Feel free to email me. We'll see you next time for part 5 and conclusion.